present?
Yes, my lady.
Yes, my lady.
Yes, my lady.
Good morning. Good morning, my lady.
Good. Mr. Keller, are you present?
Good morning.
Mr. Keller, are you present? Looks like Mr. Keller hasn't joined us yet. Okay. I'm not sure what the arrangement was, because yesterday I recall that Mr. Keller wanted to postpone his address to court after some of the other respondents have addressed. Is anyone able to advise me what has happened?
Yes, my lady. We have agreed that we will address you first on behalf of the 7th respondent, and then I understand Mr. Hodes will come after me, I think. But Mr. Hodes will confirm that.
And the 6th respondent? What is the position with the 6th respondent? Because Mr. Keller is 4th, and I think Mr. Yes.
My lady, I think if I can try to sort it out, after our deliberations, we've agreed that we will start with as indicated. Then after that, Mr. Hodes, then Mr. Ellis, then myself, and then at last Mr. Keller.
So we are starting off at this point with the 7th respondent.
Yes, my lady. That's how we've discussed it. If your lady is suitable with that arrangement.
So it's the 7th respondent followed by? Who will go after Mr. Tsetsawane?
I'm after Mr. Tsetsawane. It's Lawrence Hodes for the 10th and 13th
respondents. 10th and 13th, Mr. Hodes. You'll go after Mr. Tsetsawane.
Yes, my lady. I'll address you in respect of both to save time.
Yes.
The affidavits are very similar. Only the one has an expert, the other doesn't. That's the distinguishing feature.
And they have two different lawyers.
As your lady should please.
Yes. 13th respondent, and then followed by you, Mr. Klopper.
My lady, then the 11th respondent, Ellis, and Marlin.
Okay, Mr. Ellis. And then it would be Mr. Klopper after you.
Yes.
7th respondent. I mean, the 6th respondent. All right. And then finally, the 4th respondent.
Yes.
My lady, if I may interject, apologies for not introducing myself at this late stage of the hearing, my lady. I appear on behalf of the 5th and the 12th respondent, my lady. And if your ladyship pleases, I would like to go at the end of the submissions made by my learned colleagues.
Well, there was no appearance yesterday. Have you now been placed on record?
That's correct, my lady. The papers were emailed to your ladyship's registrar this morning. Your ladyship must just let me know if she has received it. I only received instructions late yesterday afternoon, hence my late appearance this morning, Your Worship. My lady.
No, well, I haven't, up to signing in now, logging in now, I had not received anything. So, you know, I was completely unaware of that.
My apologies, lady.
So you will go after who? After the 4th respondent?
At the very end, my lady, once my learned colleagues have presented their arguments, my lady.
Okay, and you are instructed by whom, Ms. Muller?
It's in Mula Incorporated, appearing on behalf of both the 5th and 12th.
So you the attorney that's appearing for 5 and 12?
That's correct, my lady.
What papers did you email?
My lady, it's the application for condemnation for the notice in terms of Rule 28 and along with the notice in terms of Rule 28. I will just ask my officers to check and maybe resend it, my lady. I did not have access to case lines at this point in time, hence it was not uploaded.
Thank you. Judge, we just received the papers. I'll forward them to you now. I just received them now as you've logged in.
Thank you.
Oh, it's not going to help much because if I'm busy with hearing the matter, I'm not going to have a chance to read. So, you know, we will just have to catch up with it.
Well, my lady, Norman Aronson.
Yes, Mr. Aronson.
Yeah, this does come as a big surprise.
Yes, Mr. Aronson, I'm getting there. Believe me, that's not the only surprise that that I'm faced with. I'm getting there, and I most certainly will give you a chance to talk. Just give me a minute. Just give me a minute. I just need to switch my phone off. Thank you. Right. Mr. Aronson, let me hear you on that. The fact that, well, I understand that Ms. Muller was only instructed yesterday. And, well, I'm not sure what those documents actually are that were sent, but perhaps you can address me not only on the situation with regard to the 5th and 12th respondents, but we also had at about 7:45 last night, it came to my attention that the 4th and 6th respondents are continuing to file documents.
Yes, my lady, we I think pretty obviously find this all unacceptable. But we in your hands, my lady, we've indulged many of the respondents for the sake of keeping these dates and keeping the show on the road. But I think this does take the cake, my lady. I mean, at the outset yesterday, you would have recorded that the 5th and 12th are not opposed because they haven't filed any papers, and no notice of opposition, no answering papers, nothing, my lady. So if you allow them to participate, it would have and must have cost implications for all of us and my other colleagues, for the other respondents. They want to take a chunk of the hearing and further delay the conclusion of this matter. So we would object to their participation, my lady. I'm not even, obviously, because we also haven't read any of their papers, what they say by way of asking you for condemnation at this stage for a matter that's been running so long since we filed.
The screen is frozen, Mr. Aronson. I'm not sure if you can all hear me.
Yes, Judge, I can hear you.
Okay, but the screen is frozen and I can't hear Mr. Aronson.
I think it's just quiet.
No, it's frozen. I see no movement at all.
I seem to have a technical problem, my lady, because we can't hear him and it's frozen.
Yeah.
Impo, are you able to help?
Yes, my lady, I can just ask the attorney to check if Mr. Adams. Oh, here he is. I think he was just disconnected, my lady.
Okay.
There are two of him now.
Sorry, my lady.
I don't know who's. I can't. All right. Okay, I can see you now, Mr. Aronson.
Yeah, sorry.
There you are. You're not frozen. You're live.
We just had a glitch a power glitch on our side on our big screen.
Okay.
Yeah, I don't have much to add, my lady, other than to say that
Well, I didn't even hear the last bit because you froze out. You
Yes.
said you object to their participation because of the cost implications, and then you said something about condemnation, and then you froze out.
Yeah, we because we haven't read their papers, we don't even know what their reasons would or might be for coming at this very, very, very late hour in a matter where we filed initially already in December of last year to come now at this late stage, my lady. So yes, and I was just saying this would have cost implications for all of us and all the parties and council participating in this matter. If they take up time, obviously subject to your leave, and get an opportunity to participate in the case, so we would object to them being permitted to participate in the matter, my lady, at this very, very late stage. To see browser of this loading on case lines.
Right, and then with regard to the documents that were filed yesterday, Mr. Arendse, there was the heads of the sixth respondent, which was filed yesterday, which, as I said, only came to my attention around 7:45 last night, as well as now an application by the fourth respondent, failure to comply with Rule 53, the applicant's failure to comply with Rule 53 in essence. So I'm not sure, you look confused. Have you not received it?
No, and maybe my looks betray me, my lady. I'm not confused. I'm absolutely, or we are both, Ms. Fries and I are both just absolutely flabbergasted by what is nothing other than an abuse by some of these parties and our colleagues.
So you haven't even, have you not?
We've noted whatever was uploaded to case lines late yesterday and this morning, but that's the least we could. We haven't been able to properly consider their papers and to formulate our responses, my lady. Yeah, the fourth respondent's 653D notice, my lady, that is not even accompanied by an application for condemnation.
Yes. What are you proposing then, Mr. Arendse?
My lady, we propose that these parties not be permitted to participate in this hearing.
That is 5th and 12th respondent.
Yes, my lady.
And with regard to the 4th and 6th respondents' late filing of the documents that they did yesterday, well, I'm considering it as filed last night because that's when it came to my notice.
Well, similarly, my lady, there's not even a condonation application. And we submit that that notice be disregarded and be ignored.
Okay, and with regard to the 6 respondents' heads, and rather comprehensive heads, I might add, it's more than 35 pages.
What we suggest is to deal with it in the way we've dealt with other late heads by some other parties, for example, filed last Friday, is that they
One
are
party, that's the 4th respondent.
yes, there are matters that has engaged us, raised by some of the other respondents, and to that extent, we can't really complain about being prejudiced, like maybe lateness, delay, and so on. But to the extent that new matter is raised, my lady, we have not had an opportunity of looking at that and dealing with them.
My lady,
if any of these,
please, I will give each of you a chance. Please just give me a chance to finish with one at a time, because otherwise it's just going to be a cacophony of sounds which I can't hear. Just give me a moment. I'll give each of you an opportunity.
Thank you, my lady. I'm for the 4th respondent, my lady.
Yes, you'll get a chance to speak.
Thank you.
And six.
With regard to the 6 respondents' heads, Mr. Arendse, are you going to deal with it as you had proposed to do with the 4th respondents' heads that were filed late?
Yes, my lady.
Reply.
4th, 6th, and 7th. 4th and 7th filed on Friday.
7th. I don't have the 7th respondents' heads. I've not even seen them.
I think they filed on Friday.
I haven't seen it. The only one I saw was the 4th respondents. That was late on Friday afternoon. So I have not seen anything from the 7th respondent other than that application that they brought earlier a week or so before.
So our approach would be the same. 4th, 6th, and 7th filed very late. Matters raised in their heads of argument, also raised by the other respondents. We're quite happy to deal with that. But any new matter, we've requested to deal with that in reply, my lady. But for the rest, we abide whatever decision you take. As far as 5th and 12th is concerned, completely unacceptable to come at this late stage. They should not be permitted to participate. If they want to, and if they're serious about participating and bring a condonation application, and they want the matter to be postponed, then obviously that has cost implications for all of us.
Well, not to mention time implications.
Yes, and that's why all my colleagues that have participated thus far have said have been agreed that we should conclude the hearing this week because of availability problems next year. I'm sure by now running into April, May, June even.
Oh no, that's very optimistic. I'm not available till July.
Well, there you are, my lady.
Right. Let's go down the line and let's start with Ms. Muller. You've heard what Mr. Arendse has, oh no, sorry, before you do that, let me just go down to the other respondents. We are looking at Mr. van der Vyver. Are you there?
I'm here, my lady.
Good, Mr. van der Vyver. What is your attitude to this late participation of the fifth and 12th respondents?
Oh, my lady, as I say, I haven't read the papers in terms of what condonation reasons they may say, but I say at this late hour, and if it is going to derail the process, it should not be allowed.
Well, I can't see how it won't derail the process, Mr. van der Vyver, because if it has to be considered, we have to take an adjournment, possibly for the rest of the day, to consider these papers that all parties need to consider. The tribunal itself has to consider it. It has to be then argued, and then a ruling has to be given. So I can't see how it won't derail or seriously impinge on the time that the others have been allocated this week. So you say you also object to the participation?
Yes, my lady.
Thank you. And then we've got Mr. Keller. What do you have to say about the participation of the 5th and 12th respondents?
As it pleases the court, my lady. My lady, I share the same sentiments with the court, my lady. We did not have the benefit of reading the papers, of considering them, and then thereafter taking an instruction. I'm with my lady in as far as, in fact, affording us. The delay is inevitable in this regard. Before we can address you in that particular regard, we need to have, my lady, as you have correctly pointed out, consider the papers, read the application, and then thereafter address you. So I'm with the court, my lady, in as far as I share the same sentiments with the court in as far as that particular issue involving those respondents is concerned. And that will also give me an opportunity of obtaining instructions in the process. But we can't just now, Malek, at this juncture, without even reading the papers, without even considering the application, simply say, we don't want them to be part and parcel of this process. That is our stance in this regard, Malek.
Thank you, Mr. Keller.
I'm not sure whether the leadership would like me also to deal with the issue of Rule 53, or else perhaps at a later stage.
No, I'm just dealing at this point with the participation of 2 of the respondents who were not even here yesterday. Let's deal with that, and then I'll go on to the late filing of all the other papers.
Thank you, Malek. Thank you.
Mr. Klopper?
My lady, we have no information about any papers filed. We cannot say anything on that issue.
So you haven't even seen the papers yet?
No, my lady, but we can't say anything.
Mr. Satsawana?
May I please the court, my lady? We also object to these affidavits being filed at this late stage. My lady, as far as my client is concerned, it's not only about the tribunal's availability to reconvene and continue with this matter. There is serious prejudice as far as my client is concerned, because the mere fact that my client is cited in these proceedings is causing enormous prejudice to them, because they are unable to participate in other tender processes simply because they are now cited as a respondent. Just the mere fact that they are cited as a respondent is a problem for them. So we'll object to the filing of any papers which will result in this matter being postponed. Thank you, my lady.
Mr. Hodes?
My lady, I'm going to take a practical approach to this. My view, my lady, would be that if time permits, they'd be allowed to address your ladyship right at the end. After all of the current participants, we've structured our order of addressing your ladyship already, and they would then slot in at the end. The others were accommodated, even the juniors, and other documents were filed as recently as yesterday. I don't know what your ladyship's attitude is going to be to that, but all the condemnations were granted. I haven't had sight of their papers, but if a proper case is made out for condemnation and they had opposed the relief originally, and more substantially, if time permits within this week, then I would have no objection to them participating, but I'd be against any delays to July of next year, my lady.
Yes, well, how is that going to work out in real terms? They're just going to sit through the week, and if there's time, then they will address at the end. Or alternatively, if there is no time, if we run out of time, then that's them out of the running.
As your ladyship pleases, yes.
That I'm asking, is that how
Yes.
you envisage it going forward?
Yes, my lady, I don't envisage us taking the full week. So I understand Mr. Tatswani will be this morning, to take this morning to lunchtime. I'll be this afternoon. The others will continue tomorrow, and I believe there will be time before Mr. Orense replies within the week, and I do believe it's accommodatable, but that would be the overriding factor, the time constraint. That's my only issue. Thank you, my lady.
Right, Mr. Ellis, you're for the 11th respondent.
Thank you, my lady. My lady, we align ourselves with the views expressed by Mr. Hodes.
Right, I think I've covered all of you. Right, Ms. Muller, you have heard all of this, all the views of all the other parties involved in this matter. I don't know if you want to say a few brief words now, because we cannot deal with your matter now at this point. Nobody's read the papers yet.
I understand that, my lady. If I may just make a few points, my lady. There was a notice of intention to oppose that was served already in February, my lady, and that appears on 079-613 and 614 on case lines, my lady, on behalf of the 5th and the 12th respondents. So there is a notice to oppose before, my ladyship. Whilst I accept that the application for condemnation and notice in terms of Rule 28 is late, my lady, I received instructions at 4 o'clock yesterday afternoon. Notwithstanding late instructions, there is papers filed before this Honourable Commission, my lady. I believe that I may be able to make submissions before my ladyship insofar as the condemnation is concerned. I am advised that there were late filing of pleadings yesterday, my lady, where condemnation was granted. So there has been delays in...
There's no condemnation granted yet for pleadings or process that was filed yesterday. The condemnation dealt with earlier on, before the start of the hearing, albeit that they had filed late before the start of the hearing. Those, and of course that was dictated by the attitude of the co-respondents as well as the applicant in this matter, and therefore the court had considered and granted condemnation in respect of those matters. But as for yesterday's matters, I'm still going to do the round table there. I just needed, because yours is a separate issue of participating, which is a serious issue and has enormous cost implications for everybody in this matter. So I just need to hear if you have any remarks, and especially if you have any response, particularly to, well, everybody except Mr. Hodes and Mr. Ellis seem to think that we should accommodate you, but at the end. But that's provided we have time. So I just want to hear you on that aspect. What are your views and what do you propose?
So the 5th and 12th respondent have no intention to firstly delay the matter, my lady. We're not intending to take any new legal points or not intending to raise any new legal points that have not already been raised before this Honourable Commission, my lady. The matter is of significant importance, and I'm happy to go with the suggestions made by Mr. Hodes and Mr. Ellis insofar as our submissions being made at the end, my lady. I believe that there will be no prejudice to be suffered by the respondents in that regard.
But you haven't even filed, or the 1st and the 12th haven't filed answering papers.
I understand that, my lady. So we, although not having filed any substantive affidavits, we're confining ourselves to the legal notice with the points raised in law.
And that you filed?
That's correct, my lady.
So what happens if we run out of time and we don't have time to hear you? Because there's 6 other respondents that still need to put their cases forward or their arguments forward, and we only have 4 days.
Understood, my lady. I do understand that the matter is running for the entire week. Like I said, we are confining ourselves to the notice in terms of Rule 28, which is very crisp on the points of law. We do not intend to belabor any points already made by my colleagues, and I believe that the issues have already similarly been raised before, my ladyship. In the circumstances, I believe that there won't be any prejudice.
Yes, now I'm not saying about that. I'm saying what happens if practically we run out of time, or physically we run out of time, because I'm not sure how long these other respondents are going to be. You know, if we're only going to do 2 a day, then we may not have time at the end. What happens then if there's no time at the end?
I understand, my lady, and I'm at the hands of the court in that respect. Like I said, there is a notice to oppose before this Honourable Commission. We are entitled to prepare submissions in terms of Section 34 of the Constitution, my lady, and I'm at your hands. If I may just add, my lady, if there is a situation where there isn't any time, I'll stand by the submissions of my colleagues.
Okay. Thank you. Yes, I'm astounded that we are faced with this kind of situation, especially where the 5th and 12th respondents have had months and months, if not almost a year, or almost actually a year since the application was launched, and have done nothing. Practically nothing. Apart from filing the notice to oppose, I can have an intention to do something and then don't follow through. What is the use of that expression of my intention? So it is in a very unfortunate situation. The prejudice suffered by especially the respondents in this matter and the applicant, of course, to have gone through this entire process for years already, and to be now at this point when the hearing has already commenced. 5th and the 12th respondent did not even have the courtesy to put in an appearance yesterday. Their attorney had to come and withdraw. It is a most unfortunate and a most unacceptable state of affairs with regard to the prejudice, because this time has been set down and allocated based on the number of respondents who actually were taking the matter forward. And I note, and with great concern, the submissions made now that Ms. Muller was only instructed at 4 o'clock yesterday afternoon. We started at 10 o'clock, and she was where we released Mr. Lorenchik, I think his name is, and she only got instructed at 4 o'clock yesterday afternoon. But in spite of that, I must commend her for being able to put some sort of documentation together at such short notice, although none of us have read it yet. And I have listened to each of the respondents, and I understand their concerns, because that is the concern I have as well. It's a time and money prejudice, because the availability, these are all senior counsel, their availability as well as the availability of the presiding officer is a big factor in wanting us to complete this hearing this week. Because if it becomes partly heard, which is really an intolerable situation, then we're only going to be able to proceed possibly in the 3rd term of next year. And that is even more intolerable. And Mr. Sasawana has already indicated that simply by being a party cited in these proceedings, his client is suffering prejudice. That's not even the money story and the cost implications for them. I also must thank Mr. Hodes for the practical approach that he has suggested. Because one wants to be able to be fair to everybody and give everybody a hearing. The stakes are high. These are serious. This is a serious matter which has serious implications for all parties. So, it is my view that I should give everybody as fair a hearing as possible and minimize the prejudice as best one can. And I think Mr. Hodes's suggestion going forward is a salutary one, that we hear all the respondents that have been scheduled for hearing, and in the order that the parties have indicated to me this morning that they've agreed upon. And if we should have time at the end of the week, and of course, that will also allow everybody to read the papers filed by Ms. Muller, then we'll be able to properly deal with it at the end of the week. So that is what I am directing, that the matter will proceed with regard to the respondents putting their arguments forward, and time permitting, at the end of the week, we will then hear the 5th and the 12th respondents. With regard to costs, if there's any such costs at this point, obviously the 5th and 12th respondents will then be responsible for such costs. That's as far as that is concerned.
My lady, may I address you?
Yes, I haven't finished, but yes, on this aspect, yes.
My lady, the practical suggestion coming from Mr. Otis is not surprising, because he has previously represented the 5th and the 12th respondents, and at the outset of this hearing said that he no longer does, and he doesn't have any instructions for them. My junior, I haven't looked, Ms. Fries has looked at these papers that have now been filed. There's no papers for the 12th respondent. The 5th respondent has filed papers which, according to her, and I have no reason to doubt what she's saying, requires us to respond by way of an answering affidavit. Much is said about Ms. Mutara's report. So this is going to require us probably to do whatever responses we require, to do it after hours. It's an absolute outrage, my lady. I think as much as it appears practical, it's just not feasible to allow them in on a conditional basis, that depending if there's time. What if we do run out of time, they don't get an opportunity to address you, and then they say they leave it in your hands? I don't think it's a practical approach at all, my lady. I think a definitive ruling is required at this stage, and the one that we have proposed is that they should not be allowed to participate. They've been aware of the Section 34 rights all along. Mr. Otis represented them, I think, in several of the case management meetings that we've had in this matter, and at no stage did they indicate an intention to participate in these proceedings, my lady. We have only accommodated the other parties with lateness and all that, because we wanted to keep these dates, and now they want to take advantage of the same indulgence, my lady. Thank you.
Well, I see that it's 11:15. Well, does anyone else have anything to say, flowing from what Mr. Arendse has said?
Yes, as it pleases you, my lady. I think the one difficulty that arises.
Sorry, is that Mr. Tsatsawane?
Yes, Tsatsawane. Yes, my lady. The one difficulty that arises from this is if these respondents are going to be allowed to speak at a later stage. Is Mr. Arendse now then going to reopen his case, then argue in response, and then we have to respond to what he says based on his answers to the issues that are going to be raised by his client? So that, I mean, if these respondents are going to be allowed to speak, then the correct approach will then be for Mr. Arendse to deal with their case, so that when we respond to Mr. Arendse's case, we take into account what he would have said in response to those cases.
And that by necessity would mean that matter had to be postponed.
Either it must be postponed, or it must stand down to enable Mr. Arendse to now then come back now as the applicant in the matter to deal with the cases that has been raised by these respondents. That's the practical difficulty that we have.
Yes, because we're going to lose a day at least, because if we had to stand down now, we've got to give Mr. Arendse, as well as any of the other respondents who want to make submissions with regard to the participation at this point of the 5th and 12th respondents. So that means we would have to stand down today. We would have to lose, if not the rest of the day, at least a big chunk of it.
That's the difficulty, my lady, yes.
Thank you, my lady.
Sorry, who's speaking now?
Kela for the fourth respondent.
Just give me a moment, Mr. Killer. Thank you, Mr. Killer.
Thank you, my lady. I confirm and present on behalf of the fourth respondent. I share the same sentiments, my learned colleague, learned friend.
Sorry, your line is very bad. I can barely hear you.
Thank you. My lady, I confirm my parents. Sorry, I align myself with what has been said by Mr. Tatawana in this regard. And I agree with him fully. And I think what he has proposed under the circumstances, in fact, practically, is going to assist this particular process. And another challenge that we are going to have is that if we can render them spectacular for the entire day, ultimately, perhaps they are being admitted to part and parcel of this proceeding. They will have to take us back again and deal with whatever we've done, in fact, for the duration of the day. So in essence, all I'm saying is that the practical approach is to deal with their issue now, and then, in fact, afford us time to deal with it, and then adjourn the matter perhaps up until tomorrow, and then we come back tomorrow and we make submissions in relation to, in fact, to their papers. That is, in fact, my suggestion as well, which in essence, I share the same sentiments with them.
I can't hear you very clearly, but I don't understand Mr. Tsatsawa's submissions to be that we should adjourn today and resume maybe tomorrow. In fact, he has a problem with us using the rest of today, and he says that it's simply going to take up time. That's how Mr. Tsatsawana, maybe I misunderstood you.
Sorry, my lady, that is correct. It is going to take time, but
Yes.
Again, the practicality of it is also a big problem, because how is Mr. Arendse now going to deal with these issues at a later stage, and are we then going to respond to Mr. Arendse relating to what he would have said in response to the cases that are now being made? Thank you.
So as far as I understand you are not in favor of it being adjourned today. You want us to carry on.
Well, if we definitely want the matter to carry on, but if some people are going to speak at a later stage, the practical difficulty is going to be,
Yes.
how is Mr. Arendse going to deal with what they say? And how are we as respondents then going to deal with what Mr. Arendse say in response, because he is the applicant?
Yes, that is well, we have to give them an opportunity to respond to whatever papers have been filed. And then as he correctly points out, we are in session at the moment, and the only time the applicant is going to get a chance to do that response is after hours. So there's again a big cost implication there, but more importantly, it's now going to take up the time that has already been scheduled this week for the hearing.
Correct, Malit. I mean, the other difficulty is, I mean, these are respondents who ordinarily will be on the same side as the likes of my clients, but some of these respondents have taken positions which are different from other respondents. Some have made concessions which we don't think they should have made. I have not even seen the papers that have been filed by these respondents, my lady. So I'm going to have difficulties even starting without knowing whether or not my correspondents have considered certain aspects which my client's places in dispute.
Yes, no, it does. I take your point, and I also listened to what Mr. Keller has said. Is there anybody else that has anything different to add?
My lady, if I may, it's not our intention to interrupt the flow of the proceedings, and we don't believe that or expect Mr. Arendse to advance his case to the extent that he does not want to. I mean, we're comfortable to go at the very end, my lady, and like I said, we will abide by any submissions made by our colleagues based on the same points of law.
Yes, but if the applicant now sees the necessity, I don't know, I haven't read the papers, I haven't even seen them yet. If they are of the view that they need to file an answering affidavit, that simply doesn't happen, you know, in a minute or two. They need time. And what do we do with it? So he files it, and then if other people need to also respond, they need time to do that as well. But it will depend on what the applicant's response is, as Mr. Tsatsawana has correctly pointed out. You know, they may want to also consider their options as to what they want to respond. Or how they want to make input with regard to the applicant's inputs or the answering affidavit that he intends to file. And that is going to be extremely difficult to complete, a process to complete in the remaining 4 days. And as we speak, we are running down into 3.5 days because we've now taken most of the morning just dealing with these issues.
I'm at the hands of the court, my lady.
Well, as I said, I've now listened to the additional submissions by Mr. Arendse, and obviously with the benefit of his junior having read the papers filed by Ms. Muller. And I have to be guided by that and what submissions he's made, because if he is now required to file an answering affidavit, and I imagine he still has to take instructions from his client, you know, then it would necessitate, at least for the rest of today, that we have to adjourn, and that also is now going to have serious, not just cost implications, but time implications with regard to the respondents who are legitimately on record. They may now run out of time to present their arguments, and it's an untenable situation all in all. I just want to consider, you know, the options a little bit, and I think this might be an opportune time to take the tea adjournment. We'll just take a 15-minute break. It's nearly 11. We'll resume at 11:15, so that we can continue. And I know we've now taken the whole morning out of Mr. Tsatsawana's time that he would have had to argue, but let's resume at 11:15, and then I'll give a definitive ruling on this. Okay, is everybody okay with that? Good. We'll take the tea adjournment now. Thank you.
As it pleases the court. Thank you, my lady.